October 2018 will likely be cited in world history books as Kavanaugh's month. This, of course, is due to the spectacle of the U.S. judicial appointment of Brett Kavanaugh, which was loudly opposed by millions of Americans in light of an accusation of sexual assault by the judge approximately 40 years ago. Despite the accusation, and after a public hearing held by the U.S. Senate, Kavanaugh was confirmed and now sits on America's highest bench. In Canada, the power to appoint judges is exercised by the executive branch of government, with the final decision held and made by the Prime Minister. A few years ago, under a political campaign promise, the process for selecting judges to our highest court became a hot topic and subsequently more transparent. A committee was established to review the applications of judges who wanted the job. This committee was tasked with selecting a short list of candidates and then making a recommendation to the Prime Minister. Again, the Prime Minister always holding the final say. And of course, guided by some of the unwritten and written constitutional principles, which dictate the jurisdiction, the language, and the overall diversity of the bench, as a side note. Unlike our neighbors south of the border, Canadian courts seem to have largely avoided the deep ideological and partisan divisions that influence judicial appointments. Or have they? Perhaps Canada's judicial selection process just lacks the transparency of the U.S. one. But is that so bad? The court has had an undeniable role in creating a forum for constitutional debate and impacted how and why we practice, think of, and criticize the law, the legislature, and the judiciary. This power, yielded by such a small group, raises important questions on who is making these decisions. How do they define right and wrong? What are their experiences? And how do these experiences affect their work, their notions of the law, and what they will decide for any given case? On this episode of the Inter-Veners podcast, we'd like to explore the appointment of Justice Malcolm Rowe, who is the first Canadian Supreme Court judge subjected to the current application process, and who participated in a public questioning period before his confirmation. If possible, let's compare the Canadian process to the US and discuss the consequences of the chosen systems. Oh, and before we begin, don't forget that we are here to have a conversation, not provide legal advice. And we're not always going to be correct in what we talk about, and sometimes there won't be a right answer, but that's not going to stop us. Without further ado, welcome back to the Inter-Veners.
Are you aware that at 9:23 on the night of July the 9th, the day you were nominated to the Supreme Court by President Trump, Senator Schumer said, 23 minutes after your nomination, "I will oppose Judge Kavanaugh's nomination with everything I have. I have a bipartisan, and I hope a bipartisan majority will do the same. The stakes are simply too high for anything less." Well, if you weren't aware of it, you are now. Did you meet with Senator Dianne Feinstein on August 20th?
I did meet with Senator Feinstein.
Did you know that her staff had already recommended a lawyer to Dr. Ford?
I did not know that.
Did you know that her and her staff had this allegations for over 20 days?
I did not know that at the time.
If you wanted an FBI investigation, you could have come to us. What you want to do is destroy this guy's life, hold this seat open, and hope you win in 2020. You've said that.
Your application that you put forward, you talked about what is the constitution of a province. And you talked about, you said it touches upon the division of powers between the federal and provincial governments. But in the chapter, you say it does not deal with, among other things, Aboriginal and treaty rights. I know that you would understand that this will play a huge role in the responsibility that you have given and in ensuring that Aboriginal rights are maintained, but that they coexist with other statutory and constitutional conventions and laws. I wonder if you could, in a short manner, though these are complex issues, but could you address that and the challenges ahead?
Yeah, in 1982, with the adoption of the Constitution Act of that year, Section 35.1 brought about a sea change in Canada. 35.1 says that Aboriginal treaty rights are hereby recognized and affirmed. They had existed. They had existed before. Their existence was beginning to be recognized by the courts in decisions such as Calder. But they were vulnerable to infringement before 1982. After 1982, they were constitutionally protected. And that was a starting point for a further statement and definition of what Aboriginal treaty rights are, which is very, very much a work in progress.
Hey everyone, welcome to the Inter-Veners. Get ready for your mind to be blown.
Blown. This week we're talking about Roe v. Kavanaugh.
Rowe and Kavanaugh. Yeah. I guess we should... Maybe I'll start because...
Who is Rowe? Who is Kavanaugh?
Okay, yeah. So
Let's inform the people.
Yeah, that's probably...
Background is
That's probably
good.
the best place to start. So when we talk about Rowe and Kavanaugh, we talk about the most recent appointments to the Canadian and American Supreme Courts, respectively. Trudeau appointed Supreme Court Justice Malcolm Rowe in 2017. Supreme Court Justice Malcolm Rowe had been on the Appeal Court of Newfoundland and Labrador and has a long, successful legal career and political career. Brett Kavanaugh, I think I'm going to make the assumption that everybody knows who Brett Kavanaugh is.
For the sake of time.
For the sake of time and energy.
Oh, no, you're right. 2016 was Roe. Apologies.
Yeah, it was like at the end of 2016.
Yeah.
And so Brett Kavanaugh was the most recent appointment to the Supreme Court. I guess he's now Supreme Court Justice, Mr. Brett Kavanaugh.
Yeah.
We wanted to talk about it today. We wanted to talk about these two individuals today and their appointment processes and the broader discussion about judicial appointment, because yet again, one of my professors asked a very interesting question one day when this was all going on several weeks ago. And I feel like we can talk about it now because we're a little bit removed from the conversations and the controversy and the feelings that maybe we can get kind of critical about this. But the question was, for whatever you think about Brett Kavanaugh, isn't it great to know, isn't there something great about being able to know all of these things about your Supreme Court
So a more
justice?
transparent process.
A more transparent process. And like the fact that there's the ability for democratically elected individuals to ask questions of a Supreme Court justice who, as we know, at least in the Canadian context, Supreme Court justices and American Supreme Court justices, like in a way, like they will set legal trends. They will set legislative trends
no doubt.
For years to come. Because sometimes when it gets down to a 5-4 split, I mean, that's one decision that is dictating new law. Mm-hmm. So isn't it great that at some point along the way, you know that you can go back, you can look at the Senate hearings of American Supreme Court justices, and you can figure out what kind of questions were asked. So you get a better understanding of who this person is as a professional. Mm-hmm. That was the question. Isn't it great that America gets to do this? Because in Canada,
what is the process?
I'm waving my arms around. What is the process? And so that's the question I think that we wanted to talk about today. And what we think about that question and what we think some of the answers should be.
So I think that to answer that question, you have to have a fundamental understanding of how these two countries have decided to evaluate judicial candidates. Mm-hmm. It's very clear from the U.S. perspective that there's kind of three things that they look at: the professional qualifications of a person, that person's judging skills based on past judgments, as well, and the last one being their ideological orientation. And whichever of those criterias ends up being the biggest depends on the judge, as well as the president, who is the nominator. What makes the U.S. system distinctly different from the Canadian system, is the fact that the presidential nominee has to have approval or confirmation from the U.S. Senate. And so there is an appearance of some sort of legislative interaction. Mm-hmm. But as we saw with Brett Kavanaugh, and as we all know based on, the U.S. perspective on deep ideological and partisan divisions, that's not necessarily going to that doesn't necessarily translate into a different outcome if there are questions if questions are brought up about someone's qualifications.
Yeah.
Sorry, that was a long way of getting to that point. Versus in the Canadian context, we do also consider their professional qualifications.
Because you have to apply.
You have to apply. It's a written application. Justice Rowe's application was made public. Once he was kind of confirmed as the candidate, his answers to all the questions were released to the public, and you could look at them and you could see what were the elements that he chose to talk about. Mm-hmm. How did he define, his philanthropic or his positions on the judiciary? You could read all of that. Yeah. The Canadian process focuses slightly less on the judging skills based on past judgments. And I think that speaks more so to Canada's or the Canadian temperament in terms of never quite bashing someone's decision, but more so correcting and gently correcting. Yeah. And there's often comments made about, whether a judge's correction of another goes too far, or the type of language used. And lastly and finally, the ideological orientation, which I think is something that Canadians have started to think about based on this mirror of the U.S. Appointment process, which was about a lot of different things, many of which we're not going to talk about today. But in terms of the decision-making process, came down to ideological differences. We don't really talk about that in Canada. No. And for better or worse, that's something we can talk about today. But in terms of your question as to, what was your question?
The question as to whether or not, isn't it great that in America, Supreme Court justices have to go through some kind of intersection with democratically elected representatives.
Yeah. So my question back to you is, isn't it great? Is that great for what? Is that great for confidence in the justice system? Not really. The U.S. doesn't really have much of that. Is as opposed to Canadians who aren't necessarily confident, but are more apathetic. Or
I don't think it's apathy.
Okay.
I don't think it's apathy. I won't use
apathy this week since I used it so much last week.
I don't think it's apathy so much as we don't, to backpedal slightly.
Yeah, I said a lot. Go back.
I think in Canada, we value secrecy. We associate secrecy with independence. I think there is a trend, and when we get into the conversations about law students talking about the ideal judge, in judicial conduct, there is a divide between how judges present themselves in the Canadian context compared to the American context. I couldn't tell you how many of our Supreme Court justices have families, what's the structure of their family, all of these things. I could definitely tell you about Brett Kavanaugh and his wife and his kids.
As well as all of the other justices on the Supreme Court of the United States.
Now, didn't the government take a kind of step to opening up the process with the latest appointment of Sheila Martin to the bench? Weren't there open committee hearings for that?
Yes. Okay, so this is what happened. This was kudos to Stephen Harper, because this was his idea about creating parliamentary committees that would be the think tank for going through applications, and the think tank, or the committee would bring a nominee forward to the prime minister. Mm-hmm. The problem is the composition of those parliamentary committees. I don't think have many democratically elected politicians. In fact,
I'm pretty sure they're all appointed.
They're all appointed people, and they're usually lawyers or legal professionals.
Who work for the prime minister.
Yeah. Who have gone through the process. I don't think they can work for their government. They're not government lawyers because they have to be outside experts, right? Who
Correct.
are coming in and then the prime minister gets to sign off on them. And that's what Harper introduced as a way to democratize
the selection process for Supreme Court justices.
Yes. And we still have elements of that now, right? There was a hearing with Rowe, with Justice Rowe. The problem is that there's still all of the discussion is still kind of behind closed doors. Mm-hmm. And some people have advanced arguments that it's kind of just a nicety that once this nominee is selected to go to the prime minister's office for approval, like that's basically who it's going to be. Mm-hmm. And all of the other things that flow from that are just niceties. And all of the politics that you see at the forefront of the American government are just in the behind doors in the Canadian
Some might
system.
argue that they're actually in the very front as well, though, in the U.S. context.
No, I mean, in America, they're at the forefront, but in Canada, some of that stuff is behind.
Got you.
Is behind closed doors.
Yeah.
So we don't get to interact or intersect. But in Canada, there's a value of secrecy, of independence, of if you know too much about an individual, then is that compromising their ability to make decisions? But I don't know. What do you guys...
So I was going to say two things. First, I want to clarify the reason why we're not talking about the most recent appointment to the Canadian Supreme Court of Canada, Justice Sheila Martin, is because Rowe was the first of the two to go through this more
process.
Transparent process that has been led by the Trudeau government.
Yeah.
The Trudeau government made a huge show of transparency in the fact that they had a public questioning period where for the first time in history, like sitting politicians and academics could put questions towards the candidate at the time who was essentially confirmed to have him answer on the spot, to demonstrate his language abilities, and to essentially bring the Canadian public into the sphere. Yeah. Justice Martin has also gone through a similar process, a little less dramatic since she wasn't the first. But I think more so to your question, I was going to say something that was really great. I remember. In terms of the culture of confusing independence with impartiality, is that essentially what you're saying?
Kind of, yeah.
I think it also speaks to how we treat, and I know we always end up talking about politics without wanting to talk about politics. It speaks to how Canadians treat their politicians. I couldn't tell you what Trudeau's kids look like. I couldn't tell you their names or how old they are or even how many he has. 3?
He has 3.
Interesting.
Really interesting.
But I also couldn't tell you like what
I think it's 3.
Premier
the point.
like, but you definitely know how many kids Trump has. You like the spectacle of the US kind of political arena is very much more for entertainment.
Okay. Pushback.
Get him.
Is the Canadian appointment system too opaque?
So, okay. Well, I think with moving towards this kind of open committee hearing initiative that was pioneered by the Harper government and put into place by Trudeau's government, I think you're moving towards a more transparent, or at least pseudo-transparent, seemingly transparent process where the public can question. Yeah. Now, the extreme of that, I think, is what we all got to see with the Kavanaugh appointment. That was a complete circus that was kind of used strategically around the midterm election time. It was totally like a partisan initiative, like both sides trying to at each other's necks, right? Yeah. So is the Canadian system too opaque? I mean, it depends what you're comparing it to. Yes, if you're comparing it to the United States system, of course it's still too opaque. As Cerise just said, we don't know exactly about Sheila Martin's, Justice Martin's, or Justice Rowe's like family situation or their backstory, et cetera, et cetera. But I don't know if that's necessarily a bad thing. So opaqueness, yes, it's definitely more opaque than the U.S. system. But again, it comes down to what you are comparing it to. Is there still room for the Canadian system to become more transparent while still keeping the integrity of that impartiality and independence of the judiciary? That remains to be seen. I guess we've only had 2 judges, right, appointed with this new kind of prioritization of transparency. Quasi-transparency. So I guess we'll have to see where it goes. So do you guys think that there still needs to be more done?
Yeah. So my follow-up question is, I mean, are there criticisms? Are there people out there who feel like that the quality of Canadian judges and particularly those at the Supreme Court, isn't up to standard, and that something in our system is broken.
Yeah. And
Right?
this goes back to what we were talking about last time with electoral reform. Is there a concrete problem with that is plaguing the judiciary, specifically at the highest level, that we clearly need to fix?
Because in
and
theory,
that can be fixed.
in theory, definitely. In theory, you're like, wait, I actually don't know how you feel about, I don't actually know. But the decisions that have come out of the Supreme Court in Canada have been quite well reasoned, have, definitely have opinions on both ends of the spectrum, right? Or no.
Unless you're of certain segments of Canadian population,
Of course, no,
you might have different opinions
without,
on that.
without.
That's true. That is true.
Decisions do have disproportionate effects on different groups.
So, and I think that probably that's maybe an angle that you can take, right?
Yeah.
There was a lot of public.
If it ain't broke, don't fix it.
There was a lot of public conversation with Malcolm Rowe and Sheila Martin about is Trudeau going to take the plunge and make this the first Indigenous justice?
Yeah.
There was a lot of
particularly in Sheila Martin's case, because it was going to be from British Columbia, Alberta, one of the provinces.
It just has to be a Western province.
Western province,
I believe.
But she was from So Western province, like there was going to be. So I think the idea of the Canadian appointment process, like I don't think we have found the perfect model.
She was from the North, though. She served as as a judge for the Supreme Court of Yukon.
But that is the Court of Appeals of the territories are linked to the Western provinces.
Gotcha.
So if you're on the Court of Appeal
in the sense that I think that the conversation as to a lot of people were upset that they felt Justin Trudeau or Prime Minister Trudeau missed an opportunity to appoint an Indigenous judge.
Yes.
And I think in the context of her qualifications and her judicial decisions, she has a better understanding than most of the North, which is predominantly, like the population is predominantly, Indigenous and Inuit. So I think that was his compromise, which is not something that is often talked about.
But these issues of, because the flip side of it is always, of course, people were going to compare that if you politicize the appointment process, you're going to get more partisanship in Canada.
Yeah.
I sometimes question that because in America, there's a two-party system. There's Democrats and Republicans. In Canada...
there are independents too.
There's actually two in the House.
But in Canada, like there is a more diverse representation in
political
committees.
parties.
And for a significant period of time, just recently, like the NDP were the official opposition. So would a Canadian Senate committee be comprised, would a Canadian Committee on Judicial Appointment be comprised of majority New Democrats and Conservatives, if we're talking about like in that period of the Harper
era. To be reflective of the government.
Right. And so like, would you have for like the first time, would you have New Democrats who are having... I don't think
so. I think Harper would have, if we're talking in the Harper era.
Yeah. But I'm just
of course, but I don't think in practice he would have allowed that.
No, but like you constantly have in Canada like these significant third parties. You have the Bloc Québécois when they had would you finally get to see, because it is liberal and conservative prime ministers who appoint the judges, right?
Yeah.
And whether or not we think that it's political, like there's obviously political.
Oh, it totally is. It's just so much more. I mean, the most political and controversial, aside from Nadon, is Brown, right? And that's the justice that Prime Minister Harper ended up appointing. He had the
You can't find any of his blogs anymore, but a lot of them were...
He has totally, cleaned his online persona. He also had the, least amount of judicial experience than anyone else who's ever been appointed to the Supreme Court of Canada. He was, the youngest person at the time to ever be appointed, I think at the age of 40-something, and will be there until he's 80.
75.
70. Literally, what's the difference?
I think...
Round up.
And so, his appointment was in response to Harper getting a lot of pushback on a lot of the other candidates that he was considering.
Right. So, for example, and because you brought up Justice Brown, if Justice Brown had to sit before some kind of open democratic process, would have these questions, hard-hitting questions, not have been asked? Right? And if you think about it in the appointment of other judges in the context who have recently faced reprimand, right? Keep your knees together. MAGA hat, all of these situations that are going on.
I'm afraid when big dark people enter a room, Calgary judge, earlier this year.
So, I do think Canada needs to, what Harper did, Trudeau needs to push it forward. But I'm worried that is going to make pushback. And as we saw it with Nadon, is the legal community going to rally around these ideas of judicial independence? And I always kind of find that at odds with some kind of principle of democracy, right? Because the legal community is certainly a faction, right? And so if they're upholding judicial independence, is that on some level saying we do not want the process to become more open with democratically elected representatives?
So
because you have Supreme Court justices who have come out and said, it's the worst way to, former Supreme Court justices have come out and said in Canada, this is the worst way to have somebody appointed to the Supreme Court. But I mean, of course they're going to say that. Of course, that's, I kind of feel silly what reporter asked them that question, because they're not going to say this is a great way to appoint someone.
Sorry, you're talking about Canadian justices, former Canadian justices.
Talking about Brett Kavanaugh's appointment.
Yeah.
I mean, of course they're not going to say, this is a horrible, of course they're going to of course they're going to say what Brett Kavanaugh went through was a horrible way to appoint somebody to the Supreme Court.
So I think two things. I think you mentioned a question earlier where you asked why there is a hesitation to make the judicial appointment process in Canada more democratic. And I don't necessarily think that's the case. I think there's a fear that is demonstrated and exemplified in the US case scenario where democracy and political divisions are often confused. And that the need to understand and know everything about a judge's ideological orientation in order to anticipate how they will vote on particular issues outweighs the benefits maybe that democracy puts in the forefront. And because people conflate democracy and their political ideologies, political divisions, to elect someone democratically is to give everyone a vote.
Yeah.
Right? In terms of how this person gets this job. And who gets this job and who is even considered for this job. But what happens is people then form little sub-parties known as political parties in order to encourage more people to vote in a particular way.
Yeah.
That's conflating the democratic process where we could all think about this rationally with the ideological, I want this person to have similar values to me because that means that they're going to come to the same conclusions that I would want if I was in their position. And to do that in the Canadian context would politicize a bench that has for decades prided itself on being independent by not inserting itself into the legislature and its policies, and instead of correcting laws or, reorientating governments when they maybe overstep and entrench on someone's rights, privileges, interests.
So
I say all that to say is, no, we don't need your democracy. Which is weird to say because in all other contexts, you would think that you would want that very rational and collaborative vote of a person, but not when the risk of the politics of the world infiltrating that.
No, exactly. And it just upholds the principle of separation of powers in the Canadian government system. You don't want to have a Supreme Court that's starting to get elected increasingly because of partisan lines by people that were elected through a democratic process. I think then you start to really run the risk of eroding that separation of powers, and the legislature starts morphing with the judiciary branch and so on and so forth.
Here's an argument.
Hot take coming up.
Majority of Canada's history has been spearheaded by liberal prime ministers.
Sorry, so the majority of
Canadian history has had a liberal prime minister.
Okay.
Prior to Stephen Harper's parliamentary committee, the prime minister makes the appointment. Prime minister finds the nominee, prime minister makes the appointment.
Yeah.
Does that mean that the majority of Supreme Court justices in Canada have been
selected due to partisan.
Yeah,
but
liberal values.
Yeah, like I don't know if I buy into the argument of the separation of the judiciary if the appointer is the political head of state, and if the political head of state has largely come from one political camp, can you not make the argument that
every decision has been politically motivated?
He's not going to, a liberal prime minister
is not going to choose like a super conservative judge.
Or is not going to choose the justice, the candidate that the entire Conservative Party or the entire New Democratic Party is behind.
I think there is some sort of truth to that argument, because the first thing that popped into my mind is, you know, in the last maybe 3 years, the government has moved towards the process of reconciliation, or has, you know, made declarations that is their intention. And in the same breath, the judiciary has struggled to recognize, you know, the colonial injustices faced by, or like the barriers faced by Indigenous people. You know, they started with the Gladue reports, Gladue case, and then, you know, there obviously have been other ones that I cannot think of right now. And yet, in a more recent decision, have kind of, in a lot of people's views, rescinded on the more political position of reconciliation in a judgment where they effectively said no, and undid a lot of work that people had been, you know, championing. And so
like Sanaha and Mikisew that have come out lately have been have been ruled against Indigenous parties.
I think this entire conversation, we've been looking at this issue or topic from like a very top-down approach. So we're looking at how the Prime Minister or how the, you know, legislative and executive branches kind of come together, interact to select the Supreme Court of Canada, right?
Yeah.
Now, I think it would be interesting to actually look at this from like a bottom-up approach. What I mean by that is Canadian judges they're appointed to like certain benches, right? Now contrast that with the United States. Their judges at the state level are all elected.
Yeah.
So what's interesting there, the automatic difference is that it's more difficult in the Canadian system. The Canadian system almost has like a check and balance safety valve for picking judges without knowing necessarily their political inclinations. It's much more difficult to kind of gather someone's political inclination from their history of judgments, because depending on the issue, if it's contract law, if it's criminal
area of expertise,
it's difficult to peg a judge specifically as a conservative. It's not the case all the time. Some judges obviously are more conservative, liberal, etc. But in the States, because they are elected, it is definitely more obvious what kind of political stripes the judges are aligned with.
I think you brought up such an interesting point where, you know, judges in the U.S. are candidates, because for Kavanaugh's appointment, they spent $7.2 million on advertising of pushing this image of a candidate for the Supreme Court, and spent millions of dollars trying to convince the country that this was
the choice for them.
The choice for them, essentially. Yeah. And for Rowe, they freaking rented out a hall at, you know, the University of Ottawa, invited some reporters, like, you want to talk to him? Sure. Like, this is all the publicity you're getting.
Yeah.
And so I think the terms of judges running, that starts at the state level, right? Yeah. In the U.S. And people run for like tiny counties, and they all, you know, I think that comes from the idea of them wanting them to be like from the community or of the community, which, you know, is naive and often has not worked out in the favor of my marginalized people in the U.S., poor people, and repeat offenders. And so it's interesting that, you know, you are elected by people, and yet you're still, your politics and the politics attached to that vote have a profound impact on the way you decide decisions and how you enforce, you know, criminal law and all these other things that the Canadian context hasn't had to deal with, because judges apply as they would for any other job, and background checks, I'm sure, are done, but they're not released to the public.
Yep.
And we're not shoving cameras in their faces and asking them to be both judge and, you know, reality star. You know, they leave that for the presidential office of the U.S.
Yeah.
I wonder. I question. I try to hypothesize with the Canadian system. The justice who made the "keep your knees together" remark has resigned.
Yeah.
But the example of the Calgary judge who talked about uncomfortable with dark people has only recently apologized. And I don't want to make I don't think that's quite the same thing as what happened in California with the Stanford swimmer, but Californians voted out that justice in 2018.
What happened in California with the Stanford swimmer?
They voted him out, right? Because he was a California state judge.
Okay.
And so the California voters voted because judges are candidates, right? They have to be elected. So he was voted out.
He's a swimmer?
No, the Stanford swimmer, the sexual assault.
The rapist. Yeah. We don't call him a swimmer. We call him the Stanford rapist.
The Stanford rapist. That the justice,
you okay
right?
There, Jacob?
Yeah, that was the justice, that was a quotable of this episode right there.
Who gave him community service or something? They voted him out. So, and sometimes I think with this Calgary judge who said that
Brock Turner, the rapist, Brock Turner,
uncomfortable with dark people. Imagine if...
And the story around that is really interesting.
If you had to if you suddenly now, what judges were going to say could affect their appointment. And what the keep your knees together thing is obviously quite severe. And not the same
But he said that during court. I think the distinction is a lot of judicial training and education has been, championed by various provinces in order to get judges up to standard in terms of Canadian values and rape culture and rape myths, right? And so those comments that he made during a criminal trial clearly influenced his ability to preside over that decision. It's interesting that that decision was then sent back to the trial level, and the same determination was made. So the man was acquitted, or I forget what we call it in Canada. And so the same decision was made, although like you said, the judge ended up resigning after the committee did...
After the watchdog of the Judicial Council of Canada
inquired into him and did a whole report. However, the Calgary judge's comments earlier this year to a group of law students talking about her comfort or discomfort in certain circles was treated totally differently and was given a slap on the wrist. But one could also say that doesn't that also affect how she will preside over decisions?
Why would a judge ever say I'm uncomfortable with dark people?
I mean, I feel like we have that question, and all the other students that day had that question, and she instantly knew that what she had said was totally fucked up because she apparently tried to backpedal for an hour and a half, wrote a letter the next day. She knew the minute she said it.
So I don't know if Canada's judicial system should go from appointed to elected, right? I don't know if we should make that just one-to-one jump. But I do think people need to start asking, because in preparation for today's episode, I guess I found out that we keep looping it back, but in episode 1, when we talked about Premier Ford, the federal government appointed the judge who overturned his legislation for the reduction of Toronto City Council, right? But So when Premier Ford came out and said, this is a left-leaning guy who got appointed by the federal government at such and such a time with such and such characteristics, and he was confirmed by a level of government, I don't know. I think about these things in a different way, because to think that the judiciary does not have a political bend, to think that we are so far above
it would be
American politics seems elitist. And even though we do not have Senate hearing committees, I think we need to start evaluating and interrogating how these judges get appointed, what power this parliamentary committee have, because it's not legislated for the Supreme Court. It's just it was created, and it's at the whim of the Prime Minister whether it exists or not. So I don't know if Trudeau could say that, no, we're not going to have a parliamentary committee before. We're just going to go back to the whole nomination process. Yeah. And it's important to us as law students because these are people that we then have to study. I mean, at least in America, you know that what Brett Kavanaugh has done if you're a law student in America. At least you are going to be able to recognize.
Yeah. You have a great sense of what Ruth Rothman Ginsburg's her name, the really old one who's I'm going to stay here for another 5 years, but she broke her 3 ribs last week, so it's really sad.
So I just
an aside of gossip. I hear what you're saying, John. I think I think you're right, and I think that Canadians, legally inclined, those who have access and are inside the bubble should be paying greater attention to the process and doing this evaluation. Because as I said earlier, there is a fear of opening up the system and changing it because it doesn't appear to be broken. And I say that totally acknowledging that judges are not representative of the Canadian population often in gender, race, religion, with the growing diversity that exists, particularly in Ontario. Like, I can't tell you how many South Asian judges there are. Probably zero. Don't fact check me on that. What are facts? But I agree that the perception that, well, at least we're not the U.S. or we're definitely not as bad as the U.S. isn't enough to remove the onus to reevaluate how we're doing it in Canada and what effects that's having. It's important to just troubleshoot the system. That's all it comes down to. Is we need to make sure that, and doing this before we have a candidate. It's better to be proactive than reactive.
Jacob Wisdom.
Bam. On that note.
Yeah. Let us know what you think, everyone. I think this is a hot button topic in Canada, and I hope that there's conversations that are continuing to be had. No, yeah, for sure. Even after Kavanaugh's appointment. And I think it's, at the end of the day, it's very dangerous to assume that we're better, we're different. And I don't think we've reached the final perfect form of the Canadian appointment system.
Thanks for listening to our episode today. We have been the Inter-Veners, and that was the deep dive on Rowe and Kavanaugh.
You've just been
intervened.
Claymore deployed.